voice 15 of a series called Courtroom Voices from AAA Insolvency. Today we are discussing a judgment called as Jaiprakash Agarwal versus Alka Prakash Agarwal and others. The name of the applicant in this case is Jaiprakash Agarwal, which is the erstwhile Managing Director of Bajargaon Paper and Pulp Mills Private Limited, and the name of the respondent is Alka Prakash Agarwal, the financial creditor in this case who provided the unsecured loan to Bajargaon Paper and Pulp Mills Limited. She agreed to the oral terms of the loan, trusting the corporate debtor to repay the amount with interest. However, when the corporate debtor defaulted on the repayment, including failing to deposit TDS amount, she sought legal recourse under the IBC by filing a petition with the NCLAT to recover her dues. Now the agreement, whatever agreement that we say, that is an oral agreement. It is between Bajargaon Paper and Pulp Mills Private Limited, the corporate debtor, and Alka Prakash Agarwal, the financial creditor. Now this agreement was made with the corporate debtor and was facing financial difficulties and needed funds to sustain its operations. The agreement involved the disbursement of unsecured loans, totally 70 lakhs of rupees. The loan was provided in 4 tranches between 2010 and 2012. The first tranche was given. Now, what is the importance of this judgment? This judgment is very important considering that NCLAT has agreed to oral agreement for filing an application under section 7 of IBC. There is no written agreement. But there are some other evidences which shows yes, it was a loan. Now on 16th October 2010, 50 lakhs were given. On 5th May 2011, 5 lakhs were given. On 12th May 2011, again 5 lakhs were given. On 10th April 2012, 10 lakhs were given. Now the terms of the agreement stipulated that the loan was to be repayable on demand with an interest rate varying between 15% and 20% per annum. There was no written contract between the parties. Instead, the terms were verbally agreed upon. Now, this is the kind of trust that they had between them. Now, the conditions of the default, like when the corporate debtor initially complied with the interest payment as per the oral agreement. However, they failed to deposit the TDS at they deducted TDS with the income tax department for some years. Now, this led the financial creditor to pay TDS and associated penalties. As of date of the filing of the petition, the corporate debtor had partially repaid the principal amount but still owed the following. Now, the total principal amount outstanding was about 41 lakhs. Interest component was also due, about 70 lakhs. TDS was also due. So therefore, the total application, including interest, including TDS, it was about 1 crore 17 lakhs of rupees. So the default conditions arose when the corporate debtor failed to repay this amount despite repeated demands, which led to the initiation of CIRP of the company. Now, in this case, this particular order was first pronounced by NCLT Mumbai. It was pronounced on 3rd of February 2023. NCLT Mumbai in their order, in fact, admitted the CIRP application by Alka Prashad Agarwal against the Bajargaon Paper and Pulp Mill Private Limited under section 7. The petition was based on an outstanding financial debt of 1.17 crore. Now, the corporate debtor, the directors, in fact, they filed an appeal before the NCLAT. The NCLAT first said, after reviewing the evidence submitted, including financial statements and TDS, they found that the debt and default has been proved beyond doubt. Consequently, the order under section 7 was passed. Then the moratorium was also imposed. The restrictions on any legal action was also done. Now, in the appeal, the National Company Law Appellate Tribunal, Principal Bench, New Delhi. The appeal was filed by Jaiprakash Agarwal, Managing Director of Bajargaon Paper, although the powers were suspended, and the respondents were again the Alka Prakash Agarwal. Now the Bajargaon Paper Mill, in fact the promoter said that the Bajargaon Paper and Pulp Mill took an unsecured loan of 70 lakhs. Alka Prakash Agarwal, based on the oral agreement, the loan was disbursed in 4 tranches. These are all the facts that NCLT already discussed. Now the applicant argued that the entire loan amount along with the interest has been paid by 2017. Now the claim of the respondent was inflated to cross the threshold limit of 1 crore under section 4 of the IBC by applying a compounded interest rate of 24% per annum without any written agreement to that effect. The section 7 application was based on forged document, including a balance confirmation that allegedly contained a forged signature of the applicant. Now the adjudicating authority has already admitted section 7 application ex parte. These were the arguments from the appellant before NCLAT. Now the respondent in fact argued that the corporate debtor had not fully repaid the loan and the amount due including compounded interest exceeded 1 crore, including interest. And they also showed the financial statements of the corporate debtor and Form 26AS, which is downloaded from the income tax website. In that Form 26AS, it was also mentioned that the TDS was deducted, and TDS was deducted based on as if it is a loan. Now the legal issue which was involved, the legal issues was whether this 1 crore should include interest. The NCLAT had yes, it should include. Then the section 7 application was admitted because it's based on the oral agreement. So the biggest and most important part of this judgment is that the NCLAT upheld the initiation of section 7 CIRP process based on the oral agreement. The NCLAT said that the oral agreement is also valid if it is substantiated by other evidences. So in fact, some other judgments like the Pawan Kumar versus Utsav Securities Private Limited and Kalpesh Dinesh Bhai Patel versus Krishna Paper, these were also cited by the applicant but were distinguished by Honorable NCLAT. So NCLAT, distinguishing other earlier judgments, very clearly held that the oral agreement of loan is valid. The insolvency can be initiated based on oral agreement, provided there are some other evidences that both the parties have treated it as loan. They have shown it in their financial statements. They have also tried to deduct TDS. So that was reflected on their conduct to accept it as a loan, and then there was a default. So therefore, the earlier understanding that the agreement is required for submission of any application under section 7 is completely ruled out. Even oral agreement would be valid for initiating any insolvency under section 7. Thank you very much. For any further query, we provide full scale consultancy on the IBC matters. So my email ID is there in the description. If there is any query, please reach out to us. Thank you very much.